All right. Iraq. Iraq just passed new law criminalizing same-sex relationships. If people of the same sex in Iraq are caught having any relations, they can end up serving as much as 15 years in prison. Gender-affirming care in Iraq and wife swapping have also just been criminalized. You know, it took 21 years after invading Iraq, but Republicans can finally claim mission accomplished. You got everything you wanted, Republicans. Well, I think most of us can agree George W. Bush should be prosecuted for misleading America and Congress in order to launch his illegal invasion of Iraq. But after George W. Bush and Dick Cheney left office, it was generally agreed that it wouldn't be good for America to prosecute the ex-president. And by wouldn't be good for our country, they meant it wouldn't be good for George W. Bush or George W. Bush's vice president, Dick Cheney. I got news for you. George W. Bush and Dick Cheney wasting away in Leavenworth right now, your life wouldn't be any different. It would probably be much better, America. Because those two got away with Iraq, Donald Trump figured, I can get away with stealing an election. And so far, he's figured right. The issue facing our Supreme Court right now, can an ex-president be tried for crimes they committed in the Oval Office? Last Thursday, the 6 conservative justices sitting on the Supreme Court said this question could be the single most important issue they ever decided upon. And that means we should expect a ruling from them any year now. That's just how important they feel this is. They may hand down a ruling this decade or maybe the following decade, but we should hear from them on this very important question sometime this century. If you listen to deliberations, the Supreme Court seemed to agree that Donald Trump can be tried for crimes he committed as president. They mostly agreed an ex-president does not enjoy absolute immunity. But conservatives on the court, of which there is a 6-vote majority, the conservatives indicated they're not particularly concerned about Trump's Washington, D.C. election interference trial, where he ordered his mob to take arms against our government, or they don't seem too concerned about that trial down in Miami, where Trump is charged with violating the Espionage Act. The court doesn't seem too concerned, which suggests Trump's delay tactics are working just like he planned. And most assuredly, Americans will be casting their votes this November without any foreknowledge of a guilty or not guilty verdict. On one side of the oral arguments, you had the lawyer representing the United States government, and that government, of course, would be the one Donald Trump attempted to overthrow. The government, well, that would also be Special Counsel Jack Smith, who wants to continue prosecuting Donald Trump. And the lawyer representing us, the government, and Special Counsel Jack Smith, the lawyer representing all of us before the Supreme Court, was Michael Dreeben. On the other side was Trump's defense attorney, D. John Sauer, who argued Trump can't be prosecuted because former presidents cannot be held accountable for any crimes they may have committed while in the Oval Office. Not in attendance, Donald Trump, who desperately wanted to be there, but Judge Juan Merchan, presiding over Trump's Manhattan criminal trial, wouldn't permit the gastric-distressed Trump to attend oral arguments, which, had Trump appeared, most certainly would have become anal arguments. Yeah, I went there. Lawyers representing the government, that would be Special Counsel Jack Smith. Lawyers representing us admitted ex-presidents can't be prosecuted for crimes they are alleged to have committed while performing their official duties as president. But, they argued, ex-presidents can be prosecuted for any crimes committed that are separate from their official functions, as articulated in Article 2 of the United States Constitution. Article 2 covers the executive branch. 1 is Congress. Article 3 covers the Supreme Court. So lawyers for the government say that ex-presidents can be prosecuted for crimes they committed in office that are separate from their official functions as president. For example, the government's attorney said President Obama can't be prosecuted for the drone strikes he ordered on American civilians. Rather reassuring, isn't it? Everyone agreed on Thursday that the President of the United States can kill us. That's a relief. The government's attorney said while some might consider American civilians being killed by the president to be criminal, you think? President Obama committed those murders while performing his official duties as commander-in-chief. Makes sense. I mean, what's the point of having an entire military at your disposal if you can't start checking names off your enemies list? Seems like one of the perks to being president. You get your own chef, a personal valet, and you get to take out all those who done you wrong. President Feldman, shall we work on next year's budget? Can't talk. We're only up to the D's, and that means I get to go after Mr. Delacroix, my 8th grade gym teacher. You might remember in 2011, President Obama ordered a drone strike that killed U.S.-born cleric Anwar al-Awlaki. But it was okay. It was perfectly fine because before going into politics, Obama was a constitutional law professor. So he had what I like to call Article 2 training. He knew what he was doing, killing an American citizen, because he's a trained professional. And later that year, President Obama accidentally killed al-Awlaki's 16-year-old American-born son, but unintentionally. And it was done by a CIA drone strike in Yemen. Again, it was okay because Congress had declared war on Yemen, and Obama, as commander-in-chief, was well within his constitutional right to order the accidental killing of an American citizen, even though Congress never actually declared war on Yemen. But again, it's okay because Obama used to be a constitutional scholar. He taught constitutional law. And if the President of the United States is a constitutional scholar, he doesn't need permission from Congress to indiscriminately bomb what he decides are failed states. You know, Yemen, Syria, Iraq, Somalia, they can all be bombed by America without any permission from Congress if Obama determined they're failed states. And as long as Obama was bombing failed states, we should all consider ourselves lucky he didn't order an airstrike on this country. Which brings me back to Donald Trump, who kind of did on January 6th. He didn't order an airstrike, but he did order an attack on the United States. The government Thursday argued that when Donald Trump sent his mob in to kill Nancy Pelosi and Mike Pence on January 6th, that was not part of his official role as president. Why? Because he outsourced the attack. Had the attack been in-house, had Trump, say, ordered the army, or if the army turned him down, ICE agreed to storm the Capitol, then it would fall under his role as commander-in-chief. That's the take I get from Thursday's hearings, that Article 2 seems to suggest a president must rely on trained professionals to overthrow the government, not freelancers like the Proud Boys or the Oath Keepers. And when you think about it, it makes sense, because the Proud Boys and the Oath Keepers are not government employees. And if, God forbid, they sprained an ankle, like tripping over a flagpole while bear spraying the Capitol Police, they could sue the government for lots of money. You just can't outsource a government overthrow if you're the commander-in-chief. You got to do it in-house. Donald Trump's lawyer, John Sauer, who spent the 3-hour hearings imagining the paycheck, you got a sense he was just making some stupid argument and thinking about the money, kind of like the same way Melania thought of Hugh Jackman while she and Donald conceived their son. Anyway, Sauer, thinking about the money, argued that an ex-president does enjoy absolute immunity for anything that the president ever did while president. And in order for an ex-president ever to be prosecuted for even, say, a crime of passion like murder committed while he was president, that ex-president must first be impeached by Congress and then convicted by the Senate. Then, and only then, could an ex-president possibly be subject to criminal prosecution. Trump's attorney seems to be suggesting that if the crime was uncovered after the president left office, it would still be up to Congress to impeach and 2/3 of the Senate to convict before that ex-president could ever be subject to criminal prosecution. Now, as frightening as that sounds, it's pretty much how things have gone since George Washington was president. America has never put a former president on trial in a criminal courtroom because it's generally agreed upon that if we start prosecuting ex-presidents, well, then we'd start learning from the mistakes of our past. And instead of bombing the wrong countries, we'd provide everyone in America with free health care. And who wants that? Justice Amy Coney Barrett, a Trump appointee, seemed dubious on the idea of total blanket immunity for ex-presidents. She reminded Trump's attorney that Supreme Court justices, just like the president, are also constitutionally subject to impeachment in the House and conviction in the Senate. Justice Barrett asked if the justices sitting in this room needed to be impeached and then convicted by the Senate before they could be subjected to criminal prosecution for, let's say, bribery. Trump's lawyer answered no, arguing that only a president must be convicted in the Senate before he or she is subject to the rule of law. But Supreme Court justices, he said, can be convicted for a crime like bribery without first being removed from office. Upon hearing that judges can be prosecuted for crimes like bribery, Clarence Thomas and Samuel Alito soiled their robes much the same way their criminal activity, taking bribes, for the past 20-odd years has soiled our courts. But that's for another show. Justice Elena Kagan asked if a president would be immune from prosecution if they ordered our military to help that president stage a coup and take over the American government. Trump's attorney said staging a military coup could be interpreted as an official act act of president falling under the president's function as commander-in-chief. He added that, again, Congress would first have to impeach, and then 2/3 of the Senate would have to convict before that ex-president who staged a coup d'etat could be tried. Trump's attorney failed to mention that after a successful military coup, the likelihood of that ex-president being an ex-president, the likelihood of there being a functioning Congress and Senate to impeach and convict, the likelihood of all that falls somewhere between 0 and zilch. Trump's attorney admitted that a president staging a coup would be wrong. Wow, you don't get any more patriotic than that. Yeah. Really putting yourself out there by admitting that a president staging a coup would be bad for the country. Trump's attorney then assured everyone that there are checks and balances already in place to prevent a president from being able to pull off a coup. Yes, and one of the biggest checks and balances for the past 235 years has been the threat of criminal prosecution. That's why no president up until Trump has tried a coup d'etat. The threat of criminal prosecution, which Trump's attorney argues is unnecessary because there are checks and balances in place. Before making it to the Supreme Court, this case was tried before D.C. Circuit Court, where Donald Trump's attorney, same guy, argued that a president could order SEAL Team 6 to assassinate a political opponent. Trump's attorney told the D.C. Circuit Court that, again, it would be left up to Congress and the Senate to decide whether the president should be removed from office for ordering that president's opponent murdered. Trump's attorney told the lower court, before this made it to the Supreme Court, that only after a conviction in the Senate could a former president be subject to our criminal justice system. The D.C. Circuit Court ruled against Trump precisely because of that argument and said there is no such thing as absolute immunity. Then Trump's attorney asked the D.C. Circuit Court how many more months before the November election. And the D.C. Circuit Court said, I don't know, about 10. Said Trump's attorney, in that case, I'd like to appeal your ruling before the Supreme Court. Most legal scholars figured the Supreme Court wouldn't hear the case and let the district court's ruling stand. But with 6 conservatives, this Supreme Court said, motion to delay accepted. Delay away. So, hearings were held at the latest date possible. Last week was the latest date to schedule these hearings for the Supreme Court. And during those hearings, it was remarked that SEAL Team 6, or any member of the military, is duty-bound to ignore orders from their president or commanding officers that are illegal. That's why after Julian Assange of WikiLeaks released all those files from Chelsea Manning showing countless war crimes committed by our military in Iraq and Afghanistan, the only individual put on trial for those crimes and convicted was Chelsea Manning for leaking information about our military's war crimes, which I think sends a clear signal to all members of America's military, snitches get stitches. I think that was the conclusion Judge Jackson drew from the Nuremberg trials, that our military, he came home and said, we should instill in our military, snitches get stitches, just keep your mouth shut and obey orders. Wow. Now, it wasn't all bad for the rule of law. A majority of the justices appeared to concur that an ex-president can be criminally prosecuted for crimes committed while president if those crimes were committed performing unofficial acts unrelated to the executive branch. Lindsay Whitehurst, writing for the Associated Press, counted 5 out of 9 justices whose questioning expressed disdain for the idea of absolute and total immunity. 5 out of 9. That's a majority. Eric Tucker from the Associated Press reports that Michael Dreeben, the lawyer representing us, as well as special counsel Jack Smith, and the government that Donald Trump attempted to overthrow, Michael Dreeben drilled down to what exactly the government is prosecuting Donald Trump over. And one of the charges involved the false elector scheme. During the hearings, some justices seemed to indicate that Trump organizing phony electors was in no way part of his Article II responsibilities. Dreeben, representing Jack Smith and us, also argued that Trump goading his followers to storm the Capitol on January 6 was in no way related to his official role as president. But Trump's attorney, D. John Sauer, seemed to argue that in Trump's mind, okay, we have to get into that cavernous, empty place, in Trump's mind, putting together another slate of electors, urging Vice President Mike Pence not to certify, calling Georgia's Secretary of State to find more votes, even urging his mob, not so much to storm, but observe the Capitol as members of Congress count the votes on January 6. All those actions could be construed as presidential acts to protect the sanctity of our election process. And this is important, sadly. The president, if there ever is a trial, Donald Trump, I said the president, Donald Trump, and his lawyers will argue, if there's ever a trial, that everything he did in the lead up to and on January 6 was about exercising his Article II responsibilities to guarantee free and fair elections. There's nothing in the Constitution giving that power or responsibility to the president, but who cares? This is what Donald Trump is going to argue if there's ever a trial. Now, theoretically, if I were Trump's attorney, I could make the case that if a president like JFK could federalize the National Guard to make sure black students can attend an all-white public school, the president theoretically could order the National Guard in to make sure an election isn't getting stolen. But on January 6, Donald Trump didn't order in the National Guard. Instead, he deputized the Oath Keepers and the Proud Boys, paramilitary organizations, because he knew our real military would never obey his orders. That being said, if this ever goes to trial, Trump's attorneys will still argue that in Donald Trump's demented mind, He was protecting the elections process. Okay? That's the argument they're going to make. And that's why Trump is going to lose. He's going to lose in Washington, D.C., and he's going to lose in Miami, which is why all of this is about delaying the inevitable. Trump's going to lose if this goes to trial because special counsel Jack Smith has done a pretty good job establishing Donald Trump's state of mind in the lead up to and on January 6. According to his Washington, D.C. election interference indictment, according to Jack Smith's indictment, Trump never, ever believed he was serving as president and protecting election integrity when he orchestrated all that criminal activity. Trump was simply holding on to power by any means necessary. Jack Smith's indictment, if you read it, produces incontrovertible evidence that by January 6, everyone had already told Trump, you lost and this election was not stolen. But Donald Trump decided to steal it anyway. And he tried to steal it by outsourcing, by using outside lawyers and thugs who were in no way related to the government. Nobody working for the executive branch, except two people, I'll get to that in a second, participated in his insurrection. Rudy Giuliani and John Eastman, his attorneys who spoke on the ellipse that day and urged the mob to attack, they weren't working for the government. They weren't even working for the Republican Party. They were working for Donald Trump, and they weren't getting paid. The mob that day, the Oath Keepers and the Proud Boys, weren't working for the government. There was nothing about January 6 remotely related to Donald Trump's official capacity as president. Except for Jeffrey Clark, a low-level attorney in the Justice Department, and Mark Meadows, Donald Trump's White House chief of staff, there were no government officials involved by that time, involved in proving voter fraud or arguing voter fraud. There was not a single government official was urging the mob to seize the Capitol on January 6. There was nothing official about any of this. But if this goes to trial, Trump's attorneys will try to prove that Trump genuinely believed his actions were all about election integrity. And what that really is, when you think about it, is the insanity defense. After Trump loses in November, Trump's attorneys would be well advised for him to plead insanity. Not just Trump's insanity, but America's as well, for allowing any of this to get this far. I can't believe we're having a conversation like this. I cannot believe 6 conservative justices sitting on the Supreme Court are still pretending they're not certain if Donald Trump committed a crime. If Trump were a Democrat, they'd have no problem deciding it was a crime. So after Trump loses and the court says he can stand trial, Trump's attorneys will have to use the insanity defense. They're going to have to prove that Trump, and I'm being serious, they're going to have to prove that Trump genuinely believed he was fulfilling his Article 2 responsibilities because he's clinically insane. And I don't think you'd have that hard a time convincing a jury of that. I think we can all agree that Donald Trump is clinically insane. But while Trump is a nut job, we also know he didn't believe any of that. Even through the fog of his insanity, he never believed what he was saying, because nobody in the executive branch would help him. Everyone in the Justice Department, save one, Jeffrey Clark, told him he lost. Even Mark Meadows, his chief of staff, is now cooperating with Jack Smith and is prepared to testify that he told Trump he lost. Meadows says, in the lead up to January 6th, Meadows said, I've gone over it and you lost. But Meadows still helped Trump try to overturn the election results, which is why he's on trial in Fulton County, Georgia, and it's why he flipped for Jack Smith in the Washington, D.C. interference case. Nobody except Jeffrey Clark, the low-level Justice Department official who Donald Trump almost made acting attorney general, only Jeffrey Clark told him the election was stolen. And that's why Trump sought outside counsel from Rudy Giuliani, Sidney Powell, and Jenna Ellis, John Eastman, Kenneth Chesebrough, who were not employees of the Justice Department, and all of them have either had their law licenses suspended, taken away, or it's pending. Nobody who worked in the executive branch except for Jeffrey Clark, the attorney, the Justice Department attorney who thought he was going to become acting attorney general, nobody told Trump the election was stolen. Chris Krebs, who was in charge of election integrity for Homeland Security, told Trump in December of 2020 this was the safest, most secure election in American history. So Trump fired him. Bill Barr, Trump's attorney general, told Trump in December of 2020 there was no evidence of voter fraud. He used the term BS. Trump threw a temper tantrum, so Barr resigned. That's how we know this was all about overturning the election results, staying in power, and not election integrity. And insanity. I mean, there's no question Trump is insane. But even with the insanity, he was not investigating voter fraud. None of the hundreds of millions of dollars he raised for the Save America PAC went towards anybody who was supposedly investigating voter fraud. Again, I cannot stress this enough. Only 2 employees of the entire executive branch, when Donald Trump was president, only 2 employees of the entire executive branch were willing to assist Donald Trump after the 2020 election. They were his chief of staff, Mark Meadows, and Jeffrey Clark, a low-level attorney in the Justice Department who thought Trump was going to name him acting attorney general. Those 2, Mark Meadows and Jeffrey Clark, both indicted in Georgia and were named as unindicted co-conspirators in Jack Smith's Washington, D.C. election interference trial. Mark Meadows has flipped. So there is simply no way Trump's attorneys can argue that Trump honestly believed there was evidence of election fraud. Well, they are going to argue that, but they're going to lose. And that's why this is all about delaying, which is why after he loses come November, I think he should go with just the insanity defense. It's not like Trump's going to run again for president after this year. And why would anyone doubt Trump is insane. So this gets down to a president's official duties versus private duties. Charlie Savage and Alan Feuer, writing for the New York Times, suggested that the Supreme Court, because there are 6 conservatives, might actually rule that Trump, when he was urging Mike Pence not to certify on January 6, or ordering his Justice Department to find voter fraud, even though they were telling him none existed, those activities could conceivably be construed by the Supreme Court as falling into the bucket of official presidential responsibilities for which Trump might realize some sort of immunity from prosecution. Not justifiably, but this court, with 6 Republicans, they might say that anyway. So this is going to be an issue of what they call mens rea, establishing Trump's state of mind in the lead up to January 6th and on January 6th. And that determination is better left to a jury than the Supreme Court. And of course, a psychiatrist. We should have a psychiatrist establish his state of mind. So, what is a legitimate argument for an ex-president possessing blanket immunity? Well, there isn't. There is not a legitimate argument. But that didn't stop our conservative justices from expressing concern Thursday that future ex-presidents would live in constant fear that the new president replacing them would seek political retribution by ordering their Justice Department to prosecute that ex-president. Fear of prosecution, the conservative judges argued, would hamper a future president's ability to do their job because they'd constantly be worrying that they could be sent to prison after they leave office for something they did. I think that's a great idea. Other countries lock up their prime ministers and presidents. The job of President of the United States shouldn't be so important that we can't risk criminal prosecution of our presidents after they leave office. In fact, the more presidents we lock up, the better. It's good for the country to lock up ex-presidents. In fact, after they leave the Oval Office, lock them up, send them to Leavenworth, and then they should make the case for why they should be released. We should start their retirement in prison and try to convince us why they should be let out. The conservative justices expressed concern that ex-presidents would be victimized by a president who politicizes and then weaponizes their Justice Department to go after their enemies, which is precisely what the conservatives claim Joe Biden is doing to Trump. And this was great. Michael Dreeben, Jack Smith's attorney, responded to the threat of a president weaponizing his Justice Department. Michael Dreeben, Jack Smith's attorney, the government attorney, responded by reminding the court that federal prosecutors don't act unilaterally. They can't charge without a grand jury first handing down indictments. Dreeben said it is the grand juries that protect ex-presidents from being persecuted by the current president. Samuel Alito responded by repeating the old canard about prosecutors being able to indict a ham sandwich. But, prosecutors can indict a ham sandwich. That's been said about state and local prosecutors. Federal grand juries, especially in Washington, D.C., are very selective when it comes to handing down indictments. Judge Neil Gorsuch a Trump appointee, suggested that future presidents could circumvent prosecution after they left office by granting themselves blanket pardons in the final days of their administration. Neil Gorsuch then noted that the Supreme Court has yet to decide whether presidents can, in fact, pardon themselves. At one point, this is some really tortured logic, but it comes from Samuel Alito, and only somebody with tortured logic could overturn Roe. Samuel Alito wrote the Dobbs decision. This is an amazing statement that Samuel Alito made with a straight face. He said, blanket immunity from prosecution is what makes for peaceful transfers of power. Alito said an outgoing president is more inclined to give up their power peacefully because they don't fear going to prison. But, Alito said, if the president fears that prison awaits them after they leave office, they're more likely to do everything they can to stay in power. Yeah, kind of like Trump on January 6th. Yes, people are less likely to commit murder if they're not going to get prosecuted for that murder. That's the logic that Samuel Alito employed. If you know you're going to get convicted for murder, then you're more likely to murder someone so they don't go to the police and tell them you try to murder them. If you make murder legal, according to Samuel Alito, there would be fewer murders. Kind of like the best way to stop gun violence is giving everyone a gun, which I think Alito is also in favor of. These are Supreme Court justices. Nothing gets done in this country because of them, these geniuses. So if we had a legitimate Supreme Court here in America, which we do not, the court would have immediately ruled the next day, on Friday, that the D.C. Circuit Court was absolutely right and that Donald Trump has zero immunity for any of the crimes he is alleged to have committed in the lead up to and on January 6th. We all know running for office, even as an incumbent, is not the official role of a president. Getting reelected is political, and our Constitution, along with laws that came after, make it very clear that a president as a political entity is not acting in their official capacity as president. It's why a president is not allowed to campaign inside the Oval Office. It's why a president has to use a separate office to solicit donations. It's why presidents, up until Donald Trump, are forbidden from making re-election speeches inside the White House. Presidents are not allowed to invite donors on tours of the White House. They are not allowed to accept campaign contributions or hold fundraisers inside the White House because running for president is separate from the constitutionally defined role of president. The Hatch Act, passed in 1939 during the Roosevelt administration, mandates that the president's staff or any member of Congress and their staff must maintain a wall between their official duties and their re-election campaigns. But I should mention that the vice president and the president are not covered by the Hatch Act. However, their inferiors are, the people who work for them are, and they can't get anything done without the people who work for them. They're kind of trapped into obeying the Hatch Act. So, what protections are guaranteed to a president and an ex-president? What protections do they have from being prosecuted? It's settled law, actual settled law, that a president cannot be sued in civil court after they leave office for any damages they might have inflicted while carrying out their official role as president. The Supreme Court said so in 1982's Nixon v. Fitzgerald. But that decision also specified an ex-president is in fact subject to prosecution for any crimes they committed while in office. Nixon v. Fitzgerald is very clear about that. But even before Nixon versus Fitzgerald, it has always been assumed that former presidents could be criminally prosecuted for things they did in the Oval Office. That's why Gerald Ford felt the need to pardon Richard Nixon. President Ford then, after the pardon, was ordered to testify before the House Judiciary Committee, which held hearings to determine whether Ford's pardon was in any way the result of a deal that he had struck with Richard Nixon. Now, try to imagine today, this was 1974, try to imagine today a president agreeing to testify before the House Judiciary Subcommittee. Again, it was a little different back then because Ford was, it would be difficult for Ford to turn down the subpoena from the House Judiciary Subcommittee. I don't even know if he was subpoenaed. It might have been voluntary. He was never elected vice president or president. After Vice President Agnew resigned and pled nolo contendere on charges of corruption, Gerald Ford was nominated for vice president and then confirmed by the House of Representatives. So Ford at the time was not duly elected as president, and he was not duly elected as vice president, so he lacked political authority to ignore a congressional subpoena. I suspect that had Ford been elected vice president alongside Richard Nixon, he could have refused to testify about that pardon. So, can a sitting president be criminally prosecuted while still in office? No. A sitting president cannot be criminally prosecuted. Who says so? Not the courts, the Justice Department. It's official policy of the Justice Department, but it's not a law or a decision established by the courts. It's arbitrary. The Justice Department, which is part of the executive branch, has an Office of Legal Counsel. And back in 1973, the Office of Legal Counsel, during Watergate, wrote a memo making it the Justice Department's official policy not to charge any sitting president with a crime. You had to wait until he was an ex-president. That's an arbitrary ruling coming from the Justice Department. It's policy, not law. It can be reversed in a nanosecond. So the courts didn't rule that a sitting president can't be prosecuted. The Justice Department just decided that. You might remember Robert Mueller, in the Mueller report, failed to recommend a criminal prosecution of Donald Trump. But he also didn't clear Donald Trump of any wrongdoing. Why not? Why didn't he recommend prosecution, or why didn't he clear Donald Trump? Mueller cited the memo from the Office of Legal Counsel, and he said, I'm not here to make criminal recommendations. As far as Robert Mueller was concerned, Trump couldn't be prosecuted while he was president. But Part 2 of the Mueller report spelled out precisely how to prosecute Trump for obstruction of justice after he is impeached and convicted by the Senate and removed from office. And Trump should have been impeached after the Mueller report, and then prosecuted for obstruction of justice after he left office. And he should be prosecuted for obstruction of justice right now, based on the Mueller report. The second part of the Mueller report clearly shows Trump obstructed justice. If firing James Comey, the head of the FBI, wasn't obstruction of justice, then nothing is. It boggles the mind that Trump got away with firing the head of the FBI because he was getting too close to Trump's collusion with Putin. One interesting historical sidebar from Thursday's hearings, Alito brought up Franklin Roosevelt's internment of Japanese Americans during World War II. And Alito asked, had Roosevelt lived, whether Roosevelt could have been prosecuted after leaving office for the Japanese internment. Kind of a stupid question from a stupid man, Alito. It was the Supreme Court that upheld Roosevelt's internment of Japanese Americans with their 1944 Korematsu decision. So I don't know why Alito asked that. Prosecution of Roosevelt would have been impossible had he lived because of the Korematsu decision. That's Samuel Alito, the genius who overturned Roe. He wrote the Dobbs decision. However, it did get interesting. There seemed to be some historical dispute over the advice Franklin Roosevelt received in the lead-up to his decision to round up more than 120,000 Japanese Americans months after Pearl Harbor and intern them in detention camps. One of the justices, and I don't know who it was because I was listening, but one of the justices suggested that FBI Director J. Edgar Hoover, of all people, J. Edgar Hoover urged Roosevelt not to intern the Japanese Americans. The head of the FBI, J. Edgar Hoover, advised Roosevelt Japanese American citizens were not a national security threat. But Roosevelt went ahead and did it anyway. I thought that was interesting. Michael Dreeben, the lawyer representing special counsel Jack Smith, representing the government that Donald Trump tried to overthrow, Michael Dreeben urged the justices to keep their ruling narrow and focus solely on the indictments. Dreeben argued on behalf of Jack Smith, and he said just to the justices, please focus solely on the case against Donald Trump and do not allow Trump's attorney to smuggle other issues in that would tempt the court to broaden the scope of their decision. Justice Gorsuch, a Trump appointee, indicated he was inclined towards a more encompassing decision, noting that the court here is writing a ruling for the ages. You pompous, self-righteous bore. This is not a ruling for the ages. You can pretend not to be certain as to whether or not a president has blanket immunity, but you're not writing for the ages because the ages already know a president doesn't have blanket immunity. Pretentious prick. One day I'll talk about his mother. I've talked about his mother before. I'll talk about his mother on a future show. The Associated Press notes that Justice Brett Kavanaugh also seemed to agree that how we decide will have lasting consequences. Lasting consequences. Kind of like when a teenage girl is held down against her will by a spoiled rich kid threatening to rape her. That has lasting consequences as well, at least for the girl. Apparently not for the spoiled rich kid who held her down. Alito concurred, saying this is a very important decision that will have a tremendous impact on the future. This from the same guy who wrote the decision overturning Roe And we all know how concerned he was about the lasting consequences of the Dobbs decision. This is all part of the ploy to delay. This is, wringing your hands. We have to be very careful here and make the right decision. So we're going to take months, if not years, to decide whether or not Donald Trump can be tried for attempting to overthrow the government. This is not an important decision. We all know ex-presidents don't have blanket immunity. We all know that the Supreme Court should have never taken this case. When the D.C. Circuit Court ruled that presidents don't have blanket immunity, the Supreme Court should not have touched this case. Special counsel Jack Smith's attorney urged the court to focus specifically on the immunity that an ex-president is entitled to, and the immunity an ex-president is not entitled to as it relates solely to the criminal indictments at hand. So, the Supreme Court should have never taken this, and there should have been a ruling by Friday or today. But because 6 of the 9 justices were appointed by Trump, Bush 1 and Bush 2, if you heard the hearings, you got the feeling that this court didn't hear any alarm bells warning them that our democracy is under threat from the very crimes Trump has been charged with. You sense that as far as the 6 conservative justices are concerned, everything can wait. Don't rush things. So I may be wrong, but from what I heard, from what I'm reading, from what I'm told, it feels like the Supreme Court is going to punt, and that will serve Donald Trump very well if they punt. By punt, I mean they're probably going to remand the case back down either to the D.C. Circuit Court or back to where it originated. They probably are going to send it down to the judge presiding over the Washington, D.C. election interference trial, Judge Tanya Chutkan. And I suspect, to buy Donald Trump time, they're going to ask Judge Tanya Chutkan to parse out what she sees in the indictment as crimes committed while Trump was performing his official duties as president and crimes committed while not performing official duties as president. I think this is what's going to happen, which means the likelihood of a conviction before Election Day, 0. Once Judge Chutkan is handed the case, then she will take weeks, maybe months, holding hearings to decide as to what charges in the indictment are germane to Article 2 and which ones are not. Then her ruling will have to find its way back up to the Supreme Court, possibly stopping off at the D.C. Circuit Court for review before the Supreme Court makes their final decision. That's going to take months. I think this court is going to ask Judge Tanya Chutkan to clean out Jack Smith's indictment, separating charges stemming from what could be construed as Trump's official presidential duties, separate those from the charges stemming from his private and or political acts. This is less about justice and more about serving Trump's political interests by delaying justice. Theoretically, the court could have issued their ruling already, but they can wait as late as July. They can rule in July that they're not yet ready. They can rule they've decided to send it back down to the lower court for clarification. And by July, their term is over. And short of an emergency session, they don't return until October, so that Clarence Thomas and Ginny can ride around America in their $500,000 RV that was gifted to them. So they don't return until October, which means after the case is remanded, they wouldn't touch it again until, 3-4 weeks before the presidential election. I honestly believe that's what's going to happen. That means the election interference trial, originally scheduled for last month, will probably not take place until after the November election. And the trial in Miami, same thing. And we all know if Donald Trump wins in November, that trial, the election interference trial, along with the one down in Miami, never takes place. Look, by the time you hear this, the court may have already thrown the case out and ordered the trials to proceed. Adam Liptak, he's been on this show. He covers the Supreme Court for the New York Times. And he wrote a piece at the Times on how fast the court can move when it wants to. Liptak wrote that back in 2000, the court heard oral arguments on Bush v. Gore, and the very next day awarded the presidency to George W. Bush by stopping the vote count in Florida. Conservatives stand athwart history and scream, "Slow down," only when it suits their interests. Otherwise, it's full steam ahead. This is why Rolling Stone reports this morning that Trump, his lawyers, and campaign advisors considered it a victory before oral arguments in the Supreme Court even began. Trump and his gangsters, according to Rolling Stone, they figure they already won because they delayed the ruling. And as far as they're concerned, the worst case scenario is the two trials would begin right before the election and they would be slimmed down. Slim it to win it, as they say. Trump's lawyers, according to Rolling Stone, know perfectly well that eventually the Supreme Court will rule that a president does not have untrammeled immunity after they leave office. But a Trump insider told Rolling Stone, quote, "Hey, we already pulled off the heist. We already pulled off the heist." And by heist, they mean delaying justice. And the conservative members of our Supreme Court, all 6 of them, 6 out of 9, are probably going to get exactly what they want, or get what they claim they want. And that is for the American people to decide whether Trump is a criminal, not our courts. The conservatives on the court say they want this resolved through politics because that's how these conservative judges, these Republican judges, arrive at all their decisions, through politics, their politics. These Republicans on the court have proven themselves to be the most political jurists in modern American history. Going all the way back to Scalia, he's no longer there, writing the decision that awarded the presidency to George W. Bush, the Republicans on this court, all 6 of them, used their opinions to inform the law rather than use the law to inform their opinions. And these 6 conservative Republican judges, they like Trump. We know Clarence Thomas loves him. They have no problem with Trump because through all his sloppiness and phony populist rhetoric, they recognize that he quietly services the elite. And these justices, these 6 conservative justices are elitists. They have nothing but contempt for the mob, except the mob that stormed the Capitol on January 6. That mob was their mob. Again, these justices, these 6 Republican justices, can delay Trump's trial until maybe after the election, maybe, or right before it. Either way, though, Trump has to win. Either way. And unfortunately for Donald Trump and this court, heading into November, it's looking like this incredibly conservative court inadvertently handed a political assist to Joe Biden 2 years ago with their Dobbs decision overturning Roe. These idiots on the court, because of the Dobbs decision, may have accidentally handed the presidency to Joe Biden for another 4 years. But Donald Trump insists everything, when it comes to overturning Roe, turned out perfectly. He's the only one. But Donald Trump is bragging that he appointed the 3 justices who overturned Roe. Here he is making the claim that the best thing that ever happened for the Republicans and this country was overturning Roe.
And we were able to do that when we terminated Roe v. Wade. Now, when look at it and you look at what's happening all over the country now, states are voting. Ohio just voted. All different, by the way. It's tailor-made, and it's really working out well for people. And they're very, very happy. Every legal scholar felt for a long time. For 53 years, they've been trying to do it.
Yep, it's working out really well. New national polling from Quinnipiac shows Joe Biden either tied with Donald Trump or moving ahead. But more importantly, that same Quinnipiac poll shows abortion is now more popular than it has ever been. Abortion's popularity, thanks to the geniuses on the Supreme Court, abortion's popularity is at an all-time high. And since the Dobbs decision, there have been more abortions performed after the Dobbs decision than there were before. This spells doom for Donald Trump because he appointed those 3 idiots to the court. Well, the courts are not going to save us. We have to save ourselves. Although they did, it's unfortunate if you're a woman. I don't mean to be glib, but this Dobbs decision may end up saving the country by getting Joe Biden elected. I do believe, thanks to the Dobbs decision, Joe Biden is cruising